Well, I was very interested to hear Perry and Sarah's talks, and I was thinking about how similar certain concepts are. But of course, as they were talking, all you British lawyers will be thinking, well, at least we don't have a jury for design. Yes. Well, you might be wrong about that. I wouldn't feel too smug, because there is currently a proposal to criminalise deliberate infringement of design. And therefore I envisage in the future trying to explain must match, must fit, scope of design freedom to a blinking jury. And I would rather perhaps try and explain it to Perry's angry baby, at least only one of them. So you know, that is something, I'm actually making quite a serious point, that if we get the chance, we do need to try and resist. Having said that, I'd now like just to summarise a few of the just the very basic principles in RCD cases, and try and just hint at why they might be there. So what's important in a community registered design case? What's the most important thing? The most important thing is the appearance of the representations in the design compared with the appearance of the alleged infringement, and that is it. Now, what does that tell us? That tells us, I think, that questions of copying are not relevant. If you want to make and I've never actually been in a registered design case where the claimant, and I include myself, has not tried to suggest copying. But if you want to suggest copying, then you bring an unregistered design claim. Unregistered design, shorter duration of right, but it protects from copying some very, very small features. And therefore my first point is, it's not an appropriate right in which to allege copying. Second point is, what matters next? What matters next, as Perry was saying, is the prior art, or what we call the design corpus. And why does that matter? The reason why it matters is the greater the departure from the prior art, the wider the scope of protection, because it makes a bigger overall impression, and this is all about overall impression. Does that mean that if the infringement is closer than the prior art, the alleged infringement, then it infringes? I would suggest not. I don't think it's a simple which is closest. The question is still, does it make the same overall impression? It merely means that certain features may have more significance if they're different. Third area that's important, scope of design freedom. Why is that important? If there is less design freedom in a particular feature, then the rights in that particular feature should be narrower. If there is more design freedom, they should be broader. The reason for that, I think, is because it's not the purpose of design protection to protect functional developments. And of course, if there is restrictions on design freedom, you should find the same features in the prior art anyway. Now, none of that answers the real question, which is, how do you judge overall impression? And I'd just like to pick up a comment that Robin made, which I think goes to the heart of that. The question of how high you set the bar, in other words, how easy it is to prove infringement, depends on the attributes of the informed user. Now that the ECJ have said in the Grupo Proma case, the informed user is particularly observant and is interested in designs, and compares the alleged infringement and the representations side by side, the conclusion is going to be that in many cases he will reach the conclusion that the overall impression is different because he's particularly observant. Doesn't mean it has to be identical, but it does mean the finding of valid but not infringed will not be uncommon, because different overall impression. Now having given that little introduction, let me now lighten the mood a bit by showing you some pictures from cases, and I will try to avoid, I'll obviously try and present you with an entirely objective account, not tell you which side I was on, although I expect you'll guess as I go along. Now, this picture is from the Procter & Gamble and Febreze case, which was a case that concerned air freshener, designed for an air freshener. The one on the left is a representation from the design, and this was an important design. It got various awards. I understand at the time Toilet World talked of little else. and an interesting thing about this slide, actually, is that this was a slide that was prepared by the claimant. And it's a brilliant example of how to present this kind of case, because the one on the right is the alleged infringement, and it has been painted white and carefully lit. So whatever differences are there are completely obscured. I'll show you a couple more. This is quite a good one. You can see in the design, it has a kind of, what I called at the time, a launch pad, a bit like the Thunderbird's launch pad. It's got an ellipse on the top. And the alleged infringement, even I think from that picture, is a little bit more brutal and functional. If we skip on a few slides, you can now see what the alleged infringement actually looked like. So rather than having that rather smooth effect about the whole thing, flowing lines, nice curves, this looked a bit like a small hammer, or, as I think I put it at the time, a foreign legionnaire's kepi. So you can see that there is a kind of separation in the whole thing. And it, rather than having beautiful curves, it was a little bit more, straight. Now, P&G called their, the designer of the design, always a great mistake in the UK. Doesn't help. And she was a very nice lady who explained that for the P&G design there were 5 candidates, and they all look pretty similar, and this particular one was selected and it had won all the prizes. So I said to her, well, imagine you had this as the 6th candidate. Would that have made the grade? She said, oh no, that's absolutely horrible. Absolutely no shot. And of course, we then ran what, I'll explain what the defence became called, but the basic point I made to Robin was, well, overall impression, ours is really rather unpleasant, and theirs is really quite beautiful, which was subsequently described as the Gerald Ratner defence, who said all my products are crap. But it did succeed on the basis that the informed user would notice these differences.
And I think actually the defendant's product went off the market pretty shortly afterwards anyway.
Yeah, well, we'd been injuncted in 8 different countries, so, In fact, I gave a talk after doing this case to an interested audience, about 110, and before I started I said, how many people think that this doesn't infringe? And 2 people put their hands up. And at the end I said, well, now I've explained all the difference, how many people think it doesn't infringe? About 6. But the 3 who mattered didn't think it was infringed in the Court of Appeal, so we were all right.
The Austrians,
Austrians didn't think it infringed.
Yeah.
Yeah. Now, this is quite an interesting slide, because I'm now moving on to the Dyson and Vax case. And this was prepared, this slide, by the junior barrister, my junior barrister in the case, and he's still a believer. It's got various comments like, or these, which rather implies how different the prior art is going to be. This was the prior art, which was called the lozenge type cleaner, and I think we've all seen it. And during the trial, I had just pages and pages of stuff that looked pretty much identical, vacuum cleaners, lozenge shaped. And the point we were trying to make was, along comes the great Dyson design, and it's totally different. Now, we're not talking toilet world here. This design, it's in the Victoria and Albert Museum, it's in the Design Museum. It is an icon. Here's a brilliantly prepared picture of the alleged infringement, and here they are side by side, made to look as similar as possible. And I felt during this case I was doing really well when I spoke about the brilliance of the design and the law, but when you looked at them closely, the differences were there. So I tried to keep them round about where Perry is from the judges. But as you looked at them closely, if you look at them closely, differences emerged. So these are the representations in the design, and you will notice that this was a prototype, and the back is completely smooth. Also, you've got this banana-shaped handle, and the top has this V shape. Now, if I try and go on to the next one, this is the alleged infringement. You can see from the slide in the bottom left, it has ribs on the back, and the handle has this rather unattractive tool. The top's rather different, and the cyclone is much more of a wedding cake type effect. Is that enough to avoid infringement? Well, the UK court said yes. I'm still a bit of a believer. It does raise the question, this was an iconic design. Should it have been given, and it was miles away from the prior art, should it have been given wider protection? Well, if you ask me, it probably should. Now here we come. We've all been waiting for this, haven't we? Now, Sarah's told you a little bit about this, and I was actually quite surprised to see and quite relieved in a way that the UK courts had reached, or the US jury had reached the same conclusion on this particular right to the UK court. You had a design that was registered, I think, 6 years before the iPad was ever launched. And it's quite a chunky object, a bit of a brick in your hand. Also completely smooth. Front has a little border, back is totally smooth. And you can see there from the sides, it's quite chunky, and it's got this, what was described as a quarter circle coming up to a crisp edge at the sides. That's the back, by the way, where the arrow is. This is the alleged infringement, which we all know about. Now, the judge said, well, the front is very, very, very similar. Probably made a bit of a mess of the front at the trial, actually, myself, in that I don't think I stressed sufficiently that it's actually not that similar. And the reason why it's not that similar is that the aspect ratio is very different. So that when you look at the design, I wouldn't say it's exactly square, but it's a bit like, if you watch content on it, a bit like watching one of those old televisions where it's basically square. This is much more a cinema scope. In fact, I can see it much better on mine, but it's longer and more rectangular. I guess the key about the front was, unsurprisingly, if you looked at prior art near the priority date, TVs, computer monitors, they all looked that way. They all had a border with generally rounded corners. So, said the judge, that's not that significant. The back, on the other hand, had what we call this clutch purse effect. It lacked the restraint, if one can call it that, the minimalist aspect of the design. And the sides, and I think we can see here the top has that quarter circle crisp edge. The sides of the Samsung are much more
I have to say, but they
curved
produced this
out.
in the Court of Appeal. It wasn't produced below. And Apple produced it. I'm still at a loss to know why.
Absolutely. So, you know,
You should have done that. You didn't do your job.
I saw Apple produce it, and funny enough, I didn't object to it. There you are. So now, and here's the prior art. So I guess you can see that one all sort of fits together, computer monitor, and there we see a tablet that came before. So the backs of that prior art were very different, but the fronts were very, very similar. So that's why that conclusion was reached. Now, I could tell you a little about the publication order, but it's probably beyond the scope of my... How long have I got, Robin?
Do you want to hear it?
I'll spend 2 minutes telling you about
We're okay.
the publication order. So
You went on.
after Samsung won at first instance, came the argument about the form of order. I was not available for that. I was actually about to have a small operation, but had a very good junior barrister. And she sent me an email saying, I'm going to go for a publication order against Apple that they have to publish on their website and in newspapers the effect of this judgment. So I, about to go my general anaesthetic, sent an email saying, don't do that. I was wrong. And the reason why I said don't do that is I thought that even if the judge grants it, this will all come unstitched in the Court of Appeal. Catherine went on, got the order from the judge, and I think I was probably right that but for certain events that subsequently happened, it would have come unstitched in the Court of Appeal. It was the first time that a claimant had ever been made to publish the results of a judgment against it. There is a provision, Article 15 of the Enforcement Directive, which I don't like, which says that defendants can be forced to publish judgments on. This was the first time a claimant had done it. And fortunately for me, by the time we got to the Court of Appeal, Apple's reaction to the UK judgment, which was a final judgment of a community court, so applies through the whole of Europe, was to go and get an injunction, a preliminary injunction from the German Court of Appeal in respect of one of the tabs, saying you can't market it anywhere in the UK, based on the same design right, anywhere in Europe, including the UK, and then sent a letter saying, we're going to sue you, and did start proceedings for contempt if you continue to market in the UK, where we'd already won. So I was told this, and I was told, well, it's going to be difficult, you can't attack community judgments, Turner and Grovit, and my reaction was, look, let's just do it, shall we? So we put it in the Court of Appeal, and it did have a very considerable effect. Apple were ordered to place on their website a notice that was drafted by Robin in the judgment, basically short notice saying the facts. What they did was to publish that and add a few things, quite a few things. So that
I'd rather you just stop now, because I haven't written the judgment yet. We've made the order.
Fair enough.
We haven't.
Yeah. Well, I won't go on. You will have to wait for the next episode of that. Thank you very much.